Okay.
Highly obliged, my lord.
Just a minute. Okay. 21. Your Lordship, this is a regular bail application which was earlier placed before Justice P.J. Saikia, Your Lordship. So, in light of the notification
Yes,
number
it has to
32,
be before the same.
yes,
Okay.
placed before the same judge, Your Lordship.
Okay. List this matter before the appropriate bench.
Yes, Your Lordship.
Okay.
Obliged, obliged.
Please, Your Lordship. Lordship, this is a joint petition filed under Section 4 of the CRPC for quashing and setting aside of FIR in the Itanagar Police Station case number 177 of 2023. Here, offenses only Section 279. Section 279
Is non-compoundable.
non-compounded. Rest
What is the stage? Charge sheet, the case has already been charge sheeted.
not yet.
Then it is still under investigation.
Here, Your Lordship, the parties, petitioner number 1 and 2, they have amicably settled the matter. And
Inform the IO then. Inform the IO so that the IO
Yeah,
doesn't file charge sheet.
I have been informed, but there is a one section that is 279.
Now
which
it is
not-
still under investigation stage. How do we interfere?
Here, Your Lordship, these all sections are all petty cases. So this honorable
So that
court-
is why I'm saying you inform IO. IO will not file charge sheet against you. The case gone then. Now how do we interfere?
Here, Lordship, earlier the petitioner number 2, who is the informant, he have even made the IO of the case, OC, and written application. Still, there is a application, Your Lordship. That,
You have amicably settled the matter
yes,
by some agreement.
that, by settlement agreement. There is
Okay,
an
then
extra
with this
15,
settlement agreement, this is 279 only.
only 279.
Oh, then-
Rest are compoundable. Your Lordship. And petitioner number 1.
Inform this to IO, but make an application also that you have amicably settled the matter.
But in most of the cases, Your Lordship, it's happened like that where there is a non-compoundable. The
Hmm.
IO used to charge.
No,
it
if
later.
IO doesn't find anything, on what basis he will submit charge sheet? It is still under investigation. It's still under him,
Here, Your Lordship has a inherent power because a
under
settlement
his domain, huh? How do we, the court interfere with?
279 only.
When the case is still under investigation? Hmm?
FI can be, Your Lordship, set aside.
No, how do we set aside?
Your Lordship, in petty cases, Your Lordship has inherent power under Section 482, and here, Your Lordship, both the parties, they have reached an amicable settlement.
Yes, Mr. Darwin.
Yes, your Lordship has correctly pointed out, this is an investigation stage.
Hmm.
And there's one judge, episcopal judgment in America. And there also it was written that during investigation stage, court has to be slow. And in rare case only,
No, it's still in the investigation stage. We can't interfere with the investigation. Any case, huh? But then had the case been already charged sheeted and if you feel that this can be settled,
Only Lordship, record may be called whether charge is in file.
what record? There is no record. CD only.
Here, Lordship,
We'll hold for the case diary from the IO only. There's no record not yet before the court. Then
in petty cases, Your Lordship has inherent
how do
power
we
to-
say that don't investigate? IO may not find also, not find anything against you. How do we stop?
Your Lordship, some of in the cases used to happen like that even after we are submitting a withdrawal of complaint application before OC, later in the stage, they charge it the case.
there is a case, they charge it, then in that case, if you think that you are aggrieved, and then there is no case, nothing, the case cannot proceed, it will amount to the abuse of the process, then you file.
And on account of.
Where the
appointment,
Where is it?
page number 15, annexure 3.
No, where is the FIR?
FIR is at page number 11, 12, and 13.
Where is the complaint?
Complaint is in page number 12.
What is the agreement? What the agreement says?
Agreement there says that due to some misunderstanding, that some argument took place between the.
Have you submitted this FIR, withdrawal of the FIR before the IO?
They have verbally, they have.
Why you have entered? Submit the written one, request not to proceed with, to withdraw the FIR. If it is a petty case, if you think, then I will not proceed, even if proceed also, they will not submit charge sheet. But then we can't stop, how do we stop the investigation of the case? Hmm? Yes. Still a notice can be issued.
Yes, Your Worship, petition may be dismissed.
Let us see then. Okay.
Whether the charge is filed or not.
You obtain instruction there. Whether
Obvious.
the case has already, case is of which date?
Itanagar PS case.
No, Itanagar when?
It was,
2023 case only.
23 years.
If it is petty case, probably the case has already been charge sheeted. Just obtain instruction. Okay. Or Mr. Bhattacharya. No? A. Bhattacharya, Direct Counsel for the petitioner staff. Also heard Mr. G. Tado, Planet State of AP staff. This is an application under section 482 of the Code of Criminal Procedure 1973 for quashing and setting aside of the FIR dated. This cannot be. FIR dated 9/8/2023, which has been registered as Ita PS case number 177/2023 under section 279, 506, 427 IPC staff. For the for the scanned copy of the case diary. Mr. Taro shall also, the Daniel ADPP shall also obtain necessary instruction on a query as to whether the case has already been charge sheeted or not. Mr. Taro, ADPP, who accept notice on behalf of this respondent state shall also obtain necessary instruction. On, okay, that one. And this is matter after 3 weeks. Okay.
Oblas.
Oblas, Your.
Yes. Yes.
Lordship, this is a criminal revision petition, my lord, for washing of the FIR. If you lordship,
The respondent wanted to file affidavit in opposition.
my lord, last time someone appeared, my lord, I don't know, it's reflected in the
Not
order.
yet. Yes.
But appeared, but I don't. On behalf of the my lord, wife, someone appeared.
Menjo.
No, my lord.
E. Menjo.
No,
Oh,
he's my,
he's for application.
he's my lord, junior colleague.
Yes, yes.
Well, from opposite side.
Why
Respondent
Pangu
side.
is, why Pangu is for the state?
But the service is complete upon the respondent number two, man. I don't know why.
So affidavit not yet filed.
No.
So what to do?
If she was there, one of them. could have been
CAPR,
taken.
CAPR.
And you have a, in such a situation, it's difficult to have argument also. Right?
Yes, yes.
Once
So,
more.
okay.
The chance may be given once more, but the respondent number two.
Okay. Mr. Tapo, Learned Counsel for the petitioner, and Mr. G. Dado, Learned Additional PP for the state are present. The respondent number two is yet to file affidavit in opposition. The last chance is given to the respondent number two to file affidavit in opposition. List this matter after 3 weeks.
Yes. Okay.
Obliged.
Yes,
May I please?
yes.
This is my lord, the revision petition. Herein I am excelling, my lord, the impugned order dated 11/8/2023, page number 32 and 33.
11?
8/2023, at page number 32 and 33.
You are for the petitioner
I am for the petition.
and for the respondent?
Yes, madam, I'm for the ask.
Okay.
Page 32.
Yes, please. Page 1, 3.
32, ma'am.
3, 2.
2.
Is the impugned order?
My lord. Passed by the First Appellate Court,
Okay.
District and Session Judge, UP.
Hmm.
May I read?
Yes,
Mr. Maga Sakhtar, that is me, my lord, petitioner. The appellant is present along with his learned counsel, Mr. So-and-so. Mr. So-and-so, learned counsel on behalf of respondent is also present. The appellant has stated that he does not have any amount for depositing 20% of fine awarded by the learned lower court, that is rupees 23 lakhs 60,000. The record reveals that the appellant was found guilty for offense under section 138 of NI Act by the learned court of CGM UP White order dated 23/3/2023 and was sentenced to pay a fine of rupees 1 crore 18 lakhs and rupees 2 lakhs for loss and damages sustained by the complainant due to non-payment of check amount within 3 months. The appellant was also convicted to undergo simple imprisonment of another 1 year in default of payment of fine. The appellant have filed appeal before this court on 3/5/2023 and he has ordered by this court on 26/6/2023 to submit 20% of the fine amount, that is rupees 23 lakhs 60,000. Having failed to deposit the 20% within 1 month, this court again granted 1 week time to appellant by order dated 4/8/2023 for depositing of 20% of the fine amount. And today, the appellant being personally present before the court has expressed his inability to deposit the 20% of the fine awarded. The appellants having failed to deposit the 20% of the fine awarded by learned trial court, the appeal petition is hereby dismissed and disposed of. Send a copy of this order to the CGM UPA for necessary information. So what law says, my lord?
Hmm.
Though section 148, there is a
138.
provision, yes, that 20% interim amount has to be deposited while filing the FA. But then Honorable Supreme Court has said that is not the absolute rule. In a exceptional circumstances, like in our case, I have stated it in my paragraph 4, because this petitioner, my lord, since 2018, my lord, he had been on so many places like Guwahati, Delhi for his treatment, and entire record is annexed here. On that day also he appeared, and his inability to deposit the amount, he has pleaded before the learned first appellate court below that to my health, I had been going to so many hospitals, and due to that, I have some financial constraint. And that is the reason I could not have deposited the 20% amount. So despite of that, this appeal, it was dismissed. Kindly come to para 4, my lord. Para 4 at page 4. Simple issue can be also. May I read, my lord?
Page,
Page 4,
yeah,
paragraph 4. That the petitioner begs to state that since the year 2013, he has been a patient of seizure disorder, neuro-related illness, and psychiatric issues, and he has been undergoing treatment regularly for months in Guwahati and Itanagar hospitals, which caused him hefty expenditures. After several treatments, the petitioner could barely recover from such sufferings. Again, in the month of September 2023, his health started to deteriorate, and he had to get admitted at Institute of Liver and Biliary Sciences, New Delhi on 29/2023, wherein the doctors, after several diagnoses, have found that the petitioner is further suffering from chronic liver disease, that is CLD, ethanol plus TB. The medical treatment of the petitioner is causing a huge financial implication to him and his family members. Therefore, even after several attempts to manage the 20% amount of fine imposed by the learned court below, he could not do so. Therefore, he showed his inability to deposit the imposed amount before the learned court. However, the learned appellate court disregarded his submission and dismissed his appeal in most erroneous manner. It is to be mentioned herein that though at present the applicant is under recovery, however, the doctor has advised him for hospitalization till 24/10/2023. Therefore, till that he is undergoing treatment at Delhi. As such, the instant petition is also signed at Delhi. So photocopies of all the medical certificate.
what is the illegality there in the order there?
But in the order, my lord, law says, my lord, for the default of non-depositing of that interim amount, the appeal cannot be dismissed. It has to be heard on merit. I have a judgment. Only this issue, my lord.
So
This is in the case of Jambu Bandari, 2023-10 SCC.
now supposing you were to deposit, but you failed to deposit, you were given further time. Then also, thereafter also you did not. Then how long it can be granted? You want time, more time. You want more time,
Some more time, but
some more time.
some more time. And for that, my lord, appeal, since this is the statutory right of the any convictee.
Direction was only direction in NI case is only to deposit, only to.
Let me place the law, my lord.
Yes.
2023 SCC, my lord, page 446, paragraph 6 and 10. In this case also, my lord, similarly,
Sarah?
para 6 and 10, my lord.
Six.
Para 6, my lord. May.
Yes.
What is held by this court is that a purposive interpretation should be made of section 148 NIA. Hence, normally the appellate court will be justified in imposing the condition of deposit as provided in section 148. However, in a case where the appellate court is satisfied that the condition of deposit of 20% will be unjust, or imposing such condition will amount to deprivation of the right of appeal of the appellant, exception can be made for the reasons specifically recorded. Now kindly come to
Well,
para 10.
evident. So the condition, this is discretion,
Discretion, my lord.
then how do we?
Now kindly
Direct
come to
the
Come to
discretion be in
paragraph-
your favor?
paragraph 10, my lord.
Hmm.
The learned counsel appearing for the appellants, in this cases, both the Session Court and the High Court have proceeded on the erroneous premises that deposit of minimum 20% amount is an absolute rule, which does not accommodate any exception. So what Honorable Apex Court has said, that there is an exception, my lord. And therefore, in this case, my lord, Honorable Apex Court had interfered with the order of the
Yes. Note
uh,
amount is an.
So herein, my lord,
Now the learned trial court has exercised its discretion.
my lord,
So how do we direct that your discretion should be in your favor?
my lord, what law says, my lord,
Hmm.
since appeal is the statutory right of the any convictee, my lord,
True,
on default of such,
but you not only once, you had defaulted more than once.
my lord, 1 month thereafter, 2 weeks, at least kindly, this is my humble prayer, that after interfering with this order, I may be allowed at least 3 month time to manage, because this is a huge amount. But then, my lord, for non-depositing of that interim amount of 20%, dismissing my appeal entirely, my lord, is also not justified.
What we'll do is,
In this case, my lord, the cited judgment, what happened, my lord?
Hmm.
Immediately after conviction by the learned CGM, the appeal it was filed before the district and session judge. Thereafter, for suspension of sentence under 389(1) application, it was filed. Then suspension of sentence, it was allowed with a condition that the 20% should be deposited.
okay,
Then that again went to challenge before the High Court. Then High Court upheld that order. So Honorable Apex Court said, no, this is wrong. This is not the absolute rule that he has to deposit. But then considering the circumstances, if suppose the convictee, the appellant, justified why he could not have deposited the amount, at least some more time should be granted. And on merit, for such default, the entire appeal cannot be dismissed. This is the law.
yes.
My lord, in this Jumbo Bandari case, which has been read by my learned friend,
Hmm.
my lord, in this case, my fact of the instead case, in the case of this Jumbo Bandari case, is little bit distinguishable. Is difference. There is difference between case fact of the instead case and the case in this Jumbo Bandari case.
Okay.
In fact, my lord, in this case also, my lord, the decision of Honorable Apex Court,
Hmm.
my lord, first in my lord, SS, Colonel SS double case. That was reliable. In my lord, the instead case will my lord cover the case, the judgment passed in SS double. Wherein my lord, it is said, my lord, my lord, deposit of, my lord, this 20% amount, minimum 20% amount, which is given under section 148 of NIA, is, though, my lord, the word may is used, my lord, it should be, my lord, constituted as cell.
Constitute as?
Cell. Though word may is used, my lord,
Okay.
it should be considered as cell, my lord. And if I take your lordship to this Jumbo Bandari case, my lord, before,
His prayer is, it appears that not against the deposition, but then for time. So he is bargaining for some more time. Could have given time, could have given more time, because huge amount involved and he needs some more time. And since he is struggling for his health, to recover his ill health, and he's praying for some more time only. So here, probably the week time was given, of course. Subsequently, some time was given, but then of course it was less time, according to him. So,
now if my lord friend is on merit, my lord, I'm placing that judgment, my lord.
okay.
If my lord, my learned friend is, my lord, asking for some more time, my lord, that can
Is
be.
this your prayer,
Yes.
Mr. Tama? Is this your prayer? Time only. You are not against the deposition of the amount, but
What law says, my lord, for the default of non-depositing of the interim amount, the appeal cannot be dismissed.
No, my lord. My lord, if that is the argument, my lord, then my lord, it's yes, yes, my lord. But
if you
my
are
lord,
buying-
if
if you are
is-
praying for some more time
yes,
because
yes,
of
my-
your health, you could not
yes,
manage on time.
yes, my lord.
On time, then it's different case. But then if you're arguing, saying that for default, you can't dismiss, then you will have his argument, will have to give him an opportunity to argue also. So that will be different again.
Praying for some more.
You're praying for some more time. Say around
3 months.
3 months time. You have no objection.
My lord, if we, my lord,
Then,
go to the
yes.
case record, my lord.
yes,
My lord, so this case has been, this complainant has pursuing case since from, my lord, 2012, I think, my lord. And my lord, this is 2024, my lord. And my lord, appeal was prepared on 2023, my lord. Thereafter, my lord, many occasions he has been given, my lord.
it
Opportunity.
appears, it
Yes,
appears.
ma'am. Yes, ma'am.
Apparently, of course. we
And
before
my lord,
that
one more thing, my lord.
would be
My lord,
otherwise
this suspension, the conviction is been suspended by the landlord affiliate court, my lord. And thereafter only direction was given to deposit the 20% amount. This is not condition precedent. That was been suspended, man. Thereafter, he was directed to deposit the 20% amount. And he failed to deposit the 20% amount in spite of giving so many times, my lord, opportunity. Therefore, this ultimately this appeal has been dismissed. Well, I will pray for
Have you
if
filed
in the no no objection, my lord. In the interest of
want-
justice, in the interest of justice, let him give 2 month time, my lord. Because yes, ma'am. 2 months will be enough, my lord.
say 60 days, 90 days. So with that observation that it can be disposed of,
That can
say
be
around 3 months.
yes, ma'am.
3 months and I think it appears
Yes,
big
ma'am.
amount. How much amount?
22 lakhs.
23 lakhs, I think. 23 lakhs, 3,000.
6,018. This petitioner is being here and here in the hospitals. This is fact. That other side also they.
In which para you have stated?
Paragraph 4.
Para 4.
Yes, ma'am.
Four and
Paragraph 5.
5. Okay. You have anything to solve?
Yes, no, ma'am. My lord,
Which my brother has relied.
this is
This
now.
judgment, basing on the judgment, the High Court in this case, High Court basing on the judgment, said that this should be construed as self, not man.
Hmm.
So that was explained.
Hmm.
Therefore, in this judgment also, it is clearly said that Surinder Singh Deswal's case,
Hmm.
it was explained and provoked.
Where is
Second page.
Tara?
Second page, Surinder Singh Deswal versus Kiran. It para also my lord, it is there.
No, where?
Paragraph 5.
Tara, 5 of
Para 5 of my judgment.
this Jambu.
Yes.
Jambu
Para
Bhatta,
8
yes.
of the decision of this court in Surinder Singh Deswal.
Okay. Decision of this court?
No. By the Honorable Apex Court, which my brother is relying in this case.
Okay.
SS double case, ma'am.
It was discussed. No?
Hmm, yes.
Thereafter, only the Honorable Apex Court has held
Hmm,
that the High Court, while relying this decision
hmm.
and interpreting that the man should be construed as self, is misconceived of law. And there is no any absolute law that the compensation has to be deposited at.
What we'll do is that because it will be burdensome, what we'll do is we'll pass order on Friday.
Right.
Not Friday, Thursday, we'll pass order on Thursday. Let us list this again on Thursday, we'll pass order, okay? Because there's some more things which I have to complete it. So if I keep it just to dictate inside again, since I have some other also, it will be difficult. We'll do it on Thursday. Okay.
But my lord, one more thing.
Hmm.
Since my lord will restore the appeal
Hmm.
to its file, my lord.
Hmm.
And my lord, regarding his submission, my lord,
Hmm.
in two months' time, they will deposit the amount.
So his prayer will be recorded that then he will be, so he will comply with the deposition of, your submission would be that.
We put our all effort to deposit that amount by 3 months.
That's why I'm submitting, my lord. That's why, my lord, that will be, my lord,
Recorded.
my lord, that can be recorded. Of course, that can be recorded, but my lord, that amounts will be deposited, my lord, earlier. Thereafter, only that appeal will be restored to its file.
Strictly, if there has to be argued, my lord, then I'll be also going by merit.
So,
Let us go by the merit of this case, whether that order is justified or not.
okay, we'll list it again on Thursday then. Okay. Let's pray for by the land council for the party. List this matter again on Thursday. Huh. Okay. We'll see. We'll pass order. On the basis of that, and beyond that, if there is any, you submit.
Yes, ma'am.
That's the problem. I think, just a minute. Okay.
That's it.
Okay, yes. I'm sorry, Prof. We really sorry. Did not expect this. And then probably, Ms. Tapo is for the respondent.
Yes.
He's also there.
Mr. Tapu, he just left the premise, Your Lordship.
Hmm?
Mr. Tapu just left the premise, Your Lordship. He had some urgent work.
His associate is present, Your Honor.
Yes.
His junior associate is present.
We are present, but then Your Lordship will see, I don't think today the matter will be voted.
Today is not possible.
Not
Today it
possible.
will not be possible.
Yes.
We cannot fight with the
Yes,
person.
yes, I remember. But then this was also not expected. DB, we did not expect that DB will sit. Yeah, for such a long time.
I'm totally perplexed how to settle it down,
Hmm,
except taking time no other way.
right.
I think, my lord, 1st of July is supposed to be function.
Hmm?
1st of July.
1st of July.
From 2nd July is the holiday start.
Yes, there will be only one day.
One day.
So that one day, probably the court also, we do not know. 1st July, it falls in between the holidays. So probably court may also.
Holiday back.
Holiday. And probably the advocate may also not. Yeah, next case will be listed on that one day.
But
So
tomorrow by
probably-
any means tomorrow, ma'am.
Hmm?
When there is a division bench, I'm
No, so, yeah, This bench, division bench generally used to sit almost all day, every day, and then it takes times, it appears.
Yes.
So it will not be possible. Then I think you have to choose another date only. At your convenience. Next date will say that it will be listed as the first item in the admission.
Immediately after vacation, Your
Ah,
Lordship.
Immediately.
First July is not possible, I think. First July,
1st July not possible.
not possible. Then, obviously after vacation.
After vacation only.
Before that, I don't think your lordship can accommodate.
No. Before that, it will be difficult. Tomorrow and the after tomorrow only, not possible. No.
15th
Tomorrow's list already prepared.
will be here. Fifteenth, my lord, I think your lordship will be here.
Yes, of course. No. Yes, of course. Is praise for by 15, is it okay?
15,
If it was fixed on 16th or 17th, sir, will it be okay? 16 or 17th? Oh, take it. Bye-bye. Okay, Your Lordship. No issue.
15.
15th.
Okay, as praise for by the Lama Council for the parties. This is matter again on 18. Sorry, 15. Is for admission hearing. As admission hearing is fine. Okay.
Deeply.
obliged.
So this is a pre-arrest bail application. Offense registered against the accused is 403, 406, 182. But so far 403 is concerned, this is a bailable offense. 182 is also bailable offense. 406 is only the criminal breach of trust. Maximum punishment prescribed is 3 years here. So this is a case, Your Honor, my lord, that even if we see the FIR, my lord, now we have to deal only with the 6406 because other are bailable. Now even if we see the FIR, my lord,
Only 406 is not
406 and 406 at the maximum punishment is 3 years. Ma'am.
Hmm.
Now even in the FIR, if I read, my lord will sign that there is no prima facie case at all. Why
This
is
is AV only?
AV, my lord, interim has been granted by this honorable court, and like 41A notice was issued, and I have been fully cooperating with the investigation. And my lord knows, my lord, that the law, statute law says, my lord, that section 41 of the CRPC says, my lord, whenever the offense below 7 years, whenever the offense below 7 years, so not only the requirement of prima facie satisfaction that the person has committed the offense, that is not only the requirement for the arrest. There is another requirement is that the necessity of the arrest. What is the necessity of the arrest in the case here is, my lord? There's nothing why I'm saying, my lord. I'll just give the brief facts of the case. Rather,
What happened here thereafter?
my lord.
So you are protected by this interim order.
Yes, my lord.
So what happened thereafter?
I have been
You have
cooperating.
been arrested.
Yes, my lord. I appeared, my lord, executed the required bail bond, my lord. And since then, I have been fully cooperating. Otherwise, my lord, also, my lord, there is no case at all, my lord.
So what is your prayer here now?
My lord, this may be regularized, my lord. My lord, no, so the parameters of the law, my lord, this recently also Satyendra Kumar until 2022 also said, my lord, whenever the
Yes, just a
Yes,
minute.
we have received the case diary
What
and the complainant is appearing in person today.
complainant,
Yes, madam.
informant. Okay, so
If my lord wishes to peruse the case diary, we have the case diary.
okay. Whether after obtaining this interim anticipatory bail, whether the accused appeared or cooperated with the IO of the case.
Yes, my lord. So far, the status of the case is concerned, my lord, the IO has clearly stated that both the accused are cooperating with the investigating officer.
Okay.
And there's no further necessity of a custodial interrogation. And that was the last observation on the last occasion when the CD was produced before this one.
You have no objection if the
Yes,
anticipated
so
bail
far
is
the,
regularized.
yes, ma'am. So far the IO is concerned. IO has specifically mentioned in the status report.
Okay,
If my lord peruse it, my lord can.
so why the informant is appearing in person?
Since there was certain objection from the complainant in respect of the bail application filed by the petitioner, the complainant has filed.
IO has recorded otherwise.
No, my lord. The complainant is making an objection in respect of consideration of the bail.
Okay,
And
that is why I'm saying.
he has filed an affidavit to
But so
that
far as the accused is concerned, he is accused is
cooperating. So far the IO is concerned. If my lord peruse page number 273, the initial part, my lord. First page, my lord.
273.
273 is in the beginning, my lord.
The-
The first part.
First
A
part.
status report, my lord.
Okay,
273.
Yeah.
Down below, my lord.
this is what.
Down
major
below.
pro- Just a minute, status.
Yes, ma'am.
Yes.
Down below, bail
Yes.
comments. As of now, both the alleged accused, namely Sri Thagung Niri and Sri Bagang Tangjang, are found cooperating and are appearing before the investigating agency as and when summoned. Hence, their custodial interrogation at this stage of investigation is not warranted. This is the observation given by the investigating officer.
When the information or the FIR was lodged,
look, FIR was lodged
regarding what?
2023,
Where do we
8, 12,
find the FIR?
page number 22, 25, my lord.
22 of your petition.
My lord, my lord. Page number 22, 25.
Oh, it's long FIR.
My lord, that's why, my lord, brief, my lord, if my lord allows me, I will just give the brief facts, my lord. Not require exactly what happened. My lord, I'll just inform, as on today, the complainant has lodged 4 FIRs against me, 4 cases registered against me, in respect of the same subject matter. This is first thing. So, I'm not saying that dishonest way, but the manner in which way I have been put to subjected to the harassment, this records will speak by itself. But I just put the facts in very brief. It is, my lord, in the year 2000, this so far applicant number in item number 7, my lord, he is presently he is the assistant commandant of IRBN, my lord. So I will rather start from, my lord, bail application number 8. That is how it is related. My lord.
8 is also there.
8 correlated, my lord. It's out of the same affair.
Also 9.
8, my lord. 8 and 7, 7 and 8. So I
9 also arising out of the same FIR.
no, 9 is different.
9
is different.
Okay.
Now, my lord, 8, because facts of the case, it starts from here. My lord. What happened, my lord? I am a contractor, my lord, businessman, my lord. So I am properly settled at Bhimuk, my lord. I am a businessman. This complainant, my lord, this complainant is Mr. Manish Agarwal, the complainant, my lord. His 4 excavators, my lord, heavy machinery, there was already under my lord, that was already deployed in Yingkyong area, Mariang area, for my lord, contract work. That was already there by some other company were using his machinery for excavators at that point of time. So I was looking for an excavator because I had a subcontract work. So thereafter, somehow he came to know that I was looking for an excavator. He telephonically called me. I was at my democracy, saying that my 4 excavators are lying at Mayang Jungle. So nearby this walk site. So if I am interested, I can take the excavator. My lord, very interesting. Thereafter, my lord, on 21/2017, I went to meet him at Silapatthar. I met him. We had a discussion and a lease agreement was executed. My lord, kindly turn to page number 16, my lord. Type copy, my lord, will find at page number 18. Type copy is page number 18.
Hmm, 18.
Yes, my lord.
This is what?
Page number, this is type copy. 16, 17 is the lease agreement. My lord.
16, 17.
Yes, my lord. This is the equipment rental agreement. Type copy is at page number 18.
No.
My lord,
this is,
my lord is taking item number 8.
oh, no.
AB
No,
number
no.
59.
This is 7.
Yes, my lord.
8.
AB 8.
Item 8. Was the rejoinder was modified.
Basically, otherwise, my lord, just a brief fact. Otherwise, my lord, considering the nature of the case, my lord, I'll just give the background, my lord. This was the, my lord, agreement, my lord, whereby, my lord, 4 nose of excavators were taken on lease, my lord. My lord, page number 18, 18.
Yes, this is
Agreement, my lord.
agreement,
Yes, my lord.
intel agreement.
Yes, my lord.
Okay.
Manish Agarwal Lesser, my lord, who is the complainant in the case, and Tagung Niri, my lord, is the applicant, my lord. Then, my lord, these 4 machineries, excavators were taken on lease. Those were there at the Mariang itself, my lord. Then, my lord, advance amount of 14 lakhs was paid, my lord. 14 lakhs paid to one, my lord, will find page number 20. Kindly turn to
No,
page
no,
number.
this advance of 14 lakhs was paid by whom?
Paid by me, my lord.
To?
Applicant.
To
him.
he means the informant.
Informant means, my lord, through one Ashish Kumar Agarwal. Kindly turn to page number 20, my lord.
Yes.
This is the Ashish Kumar Agarwal because he instructed me, my lord, he instructed me that this payment should be, I issued the check and payment should be given to Ashish Kumar Agarwal. This Ashish Kumar Agarwal, during the investigation in respect of the FIR of Duimuk police case, my lord, he was called integrated. He has given the certificate that he received 14 lakhs rupees from me and check is there, check number given there. And that money was distributed as per the instruction of the complainant. Then, my lord, what happened, my lord? Then it was found later on, my lord, those excavators were not in good conditions. Then, as per the terms and condition of the lease agreement, my lord, if I repair those excavators, he has to pay me the expenditure of the maintenance as per the rental equipment. Then more than 11 lakhs rupees were raised, and my lord, out of four excavators, three of the excavators, somehow, my lord, three of the excavators were working. One of the excavators was completely not working. It is still, my lord, at the jungle, my lord, one of the excavators. Then also what happened, it surfaced later on, my lord. On earlier occasion, he had some liabilities with some of the supervisor there, my lord. His own staff, my lord.
Who? The informant?
The informant. Then the matter become complicated. Then very interesting. Now, after that entire game will start. How he has maneuvered the entire system, I'll bring on the record for his own purpose. Then he realizes he went to Mariam, but maybe that police did not register his case, maybe for whatever reason, my lord. Then what he did is, my lord, he came back to Dibrugarh. He forged a document in my name, in my letterpad, saying that, no, at that point of time, he started saying that this excavator doesn't belong to me. The applicant had agreement with, not with me, but with my mother at Dibrugarh, just to confer jurisdiction to the police, my lord. He lodged FIR against me, saying that I had entered into agreement with her mother, his mother. My lord will find very interesting, as when today the informant is saying that he is not the owner. My mother is the owner. As in today, my lord will find not a single FIR, not a single objection has been written by the mother. All he has been pursuing the matter. What he did, he forced the entire document. He lodged the FIR at Dibrugarh, saying that agreement was executed at Dibrugarh, and somehow he managed to get back out of 2 machineries. He got it written back through with the help of the Dibrugarh police station. Then one machine is still at Mariam. One machine excavator was found at Sejosa. He lodged FIR that is still under investigation. That is also against some unknown person. That is still under investigation in the Mariam police station.
So you were not giving the machinery back?
No, my lord, I am coming. Machinery is not with me. Now I am coming. Not with me. Then I applied for an anticipatory bail. My lord will see the High Court order, our court's own order. What is the observation by our own High Court, my lord? Kindly turn to page number, my lord. Slowly, my lord, thing is coming up. Page number 23, 24. These are just showing, my lord, the 23, 24, my lord. My lord, may I turn to page, kindly take to page number 24, my lord.
Okay.
Page number 24, from the bottom, 1, 2, 3, 4, 5, 5. From the bottom, my lord, 5 paragraph, my lord. I have given my NGS consideration to the contention of the learned counsel of both sides. The entire dispute arose on the basis of the written lease agreement. I do not find any incriminating material for constitution of the criminal case. Mr. So-and-so has pointed out one of the excavator is yet to be traced out. In my considered opinion, even if one of the excavator is not traceable, then also I do not find this fact to be a criminal act against the petitioner. The dispute between the informant and the petitioner is a civil dispute. I do not find sufficient materials to justify detention of the so-and-so and so. Thereafter, my lord, this pre-arrest regular bail was granted by the Honorable High Court, my lord, by order dated 6/10/2020 in connection with Dibrugarh police case.
So this is so this bail was regularized
My lord, my lord.
when you said by an order,
My lord,
by an order dated.
6/10/2020.
So no, this
This is in connection with Dibrugarh police station case.
no, this is only
My lord has got, this is
okay.
because what he did is like, my lord, to get recovery of this excavator, he forced the entire documents. Then he came with a new story that no, all this excavator belonged to my mother and all the agreement was executed in the Dibrugarh. And my lord will find very interesting. Dibrugarh police filed final report. Saying, my lord, final report, but he objected and magistrate has asked for a further investigation. But as on today, no charge sheet, nothing has been filed against him. As on today.
Further investigation, re-investigated.
For further investigation. Because police filed on the basis.
Further investigation.
Further investigation. Re-investigation cannot be.
No, after submission of the final report.
Only further investigation.
No, then he has submitted a protest petition.
He protested.
Then it should not be with the not be investigated by the same IO. It has to be different IO. Whether that kind of a direction.
No. It's given to same that to make the further investigation.
It cannot be further.
Maybe, but whatever. So, my lord, by the CGM at Dibrugarh.
Okay.
CGM at Dibrugarh, and till that, no charge sheet has been. Meaning there, why I am referring, because otherwise those things has no relevancy. Why I am referring to show that that how he has manipulated the entire document, subject to I am just saying on the probability, because those things are yet to be tried. Just I am on the prima facie basis, I am making a submission. My lord, I am not also saying to take conclusive that he has forged the document. I am saying that the prima facie, the balance is on my side. Why I am saying, my lord, how he managed to get all those excavators. Despite there being already an agreement that was executed between both of us at Silapathar, and he had subsequently manufactured the document and got those excavator returned back. That's why I am pinpointing. Now, another very interesting thing, madam. Otherwise, madam, why the Dibrugarh police have not filed, because he lost the FIR in the Dibrugarh, my lord will see, somewhere 2018. But now we are 2024. As on today, no charge sheet has been filed. This is very interesting. That itself speaks volume. That no incriminating materials could be found against me. Had I forged the document, my lord, by now definitely charge sheet would have been filed. This is how he played. Thereafter, my lord, I obtained this.
That FIR was also regarding
these 4 excavators. My lord, I will show.
Here in this FIR, what is the allegation?
Here in the allegation, my lord, very interesting. What happened? Then when he filed the FIR at Dibrugarh, then by forging my signature, all those things in the forged document, then what I did, I also lodged a complaint against him at Duimuk police station. My lord, I lodged a complaint against him at Duimuk police station on 28/4/2018. I lodged complaint against him, saying that first, while I was at Duimuk, you contacted me. You misrepresented me, saying that you are the owner of the excavator. You misrepresented me that all the vehicles were in good condition. You misrepresented me, and thereafter you forged all the documents, all my signature, and thereafter you lodged FIR. Thereafter, my lord, I lodged the FIR. My lord will find my FIR, my lord. (22) 27 28/4/2020. My lord will find
Just Rajesh,
my lord.
so let us, probably we are running out of time also.
Yes, ma'am.
So
Thereafter,
we have a less time.
Hello.
Let us see the allegation against you in this case.
yes, my lord. Just in short, my lord, I will read FIR is too lengthy. I will just tell my lord what is the allegation. Very interesting. Now, basically, it is not against me in this matter. Why am I? Then, my lord, on the basis of my FIR, Duimuk police was registered. Then the the
What
official.
is the basically, what is the allegation against?
Now I am coming. I am coming. That's why, madam. The investigation officer and the officer in charge, one of the police personnel from the police, they went to the Sejosa. They seized one excavator from there in connection with my case. So that excavator was brought here, and as on today, it is still in the Duimu police station as per the record. Now his case is that the informant case is that you have seized this excavator without the following the due process of court law from the Sejosa police. You have used it for personal use, and therefore you, in connivance with the officer in charge police station, you have lodged false FIR against me. This is the case in this case.
So there is allegation against OC also.
OC, that at that time, that's why the applicant number 7 is the earlier time he was the officer in charge of the Demo police station. As of today, he is the assistant commandant IRPM.
Applicant 77 in
Item number
AB.
7.
Item
number
7.
Yes.
AB is the accused is,
He was the officer in charge at that point of time.
okay.
So he did, my lord knows when somebody files FIR, what the law says. Whenever the FIR discloses the cognizable offense, Lalita Kumari says that officer in charge has no discretion to refuse to register the case. He has to register the
Must
case.
have been some allegation against the OC also, must have done something. That is why the allegation must have.
That's why I'm saying allegation is that that OC and we entered into connivance and thereafter brought the excavator from Sejosa.
Basically, the excavator belongs to the informant.
Belongs to the informant that was taken on lease. So at that point of time,
Lease was still in operation at that time.
it happened something like that. Out of one excavator,
Huh.
that one of the excavator, because my lord, what happened is like that. He had some liability with some other person, one Komken Nomdir or something like that. 2 excavator, my lord, kindly turn to page number.
My lord, may I kindly peruse page number 270 of the case diary. Everything will be clear, my lord. The allegation is that, my lord, from Sejosa, they have brought the excavator to Doimuk police station, and instead of keeping that excavator in the Doimuk police station, he has given it to someone, some personal individual, to use that excavator. That was the
OC has
allegation.
given that.
Yes, my lord. That was the allegation.
Okay.
Basing on that, inquiry, complaint was filed by the complainant, and inquiry was conducted by the SDPO of Balijan, and accordingly, there was a direction to register a FIR to the CB police station, crime branch, SIT.
Okay, after the inquiry, the
Yes,
case was registered.
Registered. If
Yes.
my lord may,
Found that it was used.
yes, my lord. If
Okay,
my
there
lord
is
may
an
peruse
allegation.
page 270, my lord.
Okay.
Yes. Now, excavator, there is record says excavator in the Dumu police station. This has been produced before the seizure memo. All these things are.
Just a minute, sir. 70?
270 of the case diary, my lord. Initial part. That is the
73,
270, my lord.
70.
Yes, madam.
Okay.
Gist of the FIR.
Gist, okay.
Now, if my lord may start from 4th paragraph, my lord, accordingly.
Yes, accordingly.
Accordingly, Shri Magatago, SDPO Balijan, conducted an inquiry wide order number so and so. The findings of his inquiry are as follows. As per the seizure memo of Sejosa and Doimuk PS, L&T excavator Komatsu so and so was one of the excavator given to Tagung Niri by Simiti Bimla Devi Agarwal. The excavator so and so is clearly mentioned in the seizure list of both the PS. DYSP V. Tangjang, the then OCPS Doimuk, has directed ASI Niri the excavator mentioned above in connection with Doimuk PS case number so and so, when it was already seized in connection with Sejosa PS case number 9 of 2017. Serious negligence and lapses is found against the then OCPS Doimuk for uploading the seized case property in a private individual area and to allow its use at Papunala area. The inquiry officer has also minutely checked the excavator kept seized at Doimuk PS, but could not find any serial number so and so. Hence, it could not be finalized whether the serial number has been removed or the machine itself was changed. Hence, the case accordingly case was registered White Crime Branch PS case number so and so.
Oh, this is the case.
My lord.
Now, my lord, this
Now, this is the latest item status report.
Yes, my lord. The excavator which is in dispute was later recovered from Bandardeva, my lord. And
Recovered from
Bandardeva, my lord. Bandardeva.
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 It was supposed to be here in the
Doimuk police station.
Yes.
Yes, my
It
lord.
was not.
It was It
The
was
inquiry-
exchanged.
Inquiry officer found it from, recovered from Bandadeva.
Bandadeva.
And that,
Bandadeva.
Bandadeva, that.
Yes.
From Bandadeva.
Bandadeva, if I may
Private
take my
bank.
lord to page number 81. 81 of the case diary.
Yes.
That is a Caesar list, my lord. I don't have the copy of that Caesar list.
See, from the possession of,
Prashanta Das.
articles from Brahmaputra complex.
Probably in that area, my lord.
No, it was not under the possession of any other person. It recovered from the complex. The seizure list doesn't say,
Yes.
seized from the person. It was left abandoned or it was seized from somebody?
It was seized, my lord. Maybe probably in the page prior to that Caesar list, there would be some observation given by the IO.
This is seizure list only.
Yes, my lord.
In the seizure list, it only says we have seized the following articles from Brahmaputra complex, opposite so and so, under the on so and so. In presence of. It doesn't say seized from whom. It's been made on being laid and shown by Sri so and so.
Probably Prashanta Das, my lord.
Shown by, yes, Prasanta. Who is this Prasanta?
It's one of the accused, my lord.
Oh, he is also accused.
One of the accused.
So he led and so then it is,
It was recovered.
okay, he has kept it.
Yes.
So the case is still under investigation.
Yes, my lord. Still going on. My lord.
Okay. So, but,
My lord will see.
just a minute. So, but, thereafter, although these are there, but then in the last, the police says that now the accused so and so and so and so are found, they are cooperating
Right.
and are appearing. Now, what is your submission?
My submission, my lord.
Yes.
Since I will be totally basing on the submission statement given by the IO, since as per the IO, the custodial interrogation is not necessary.
Not necessarily.
Otherwise, my lord, if I may take my lord to page number,
So, what happened after that? So they appeared before the IO.
Yes,
They
my
were found arrested.
yes, my lord, and recorded their statement.
Well, then were bond also executed.
Yes, my lord, recorded their statement under 161.
Recorded there 161.
161
So
statement.
thereafter also they are cooperating.
As and when called for, my lord.
Okay,
Now, my lord, I'll just put it precisely.
just a minute. Yeah. Then if their further interrogation is not necessary, that the bail can be made absolute.
So far, my submission, my lord.
Hmm. Okay, let the investigation complete in the meantime. Some charge sheet.
Right.
It appears that they are the case against them.
Right.
But then since they are cooperating,
Now, before he makes submission, this is law point, my lord.
yes.
Just because I will not go.
Oh,
by
what
all
do you
those
want?
Fact,
What is
fact
your-
I will not go.
Now, what is your prayer?
My lord, I'll just come. Prayer, that bail may be made absolute.
Ah.
That is first prayer. I just put the law point, my lord.
Ah.
I will not go by the facts. He will bring one fact, I will bring one fact,
No,
so
no,
many things.
we are
Just
not on
one
the
prayer,
basis-
my lord. Law now says, my lord. Now the law says, section 41 of the CRPC.
Hmm.
Offenses below 7 years.
Hmm.
Arrest is not mandatory, first point, my lord.
Hmm.
And law says, my lord, that of the whenever the police says that what needs to arrest, police has to justify the reason, giving the reason citing why arrest is necessary. This has been, my lord, recent.
And probably here in this case.
Police is saying we
here in
don't
this case,
require.
the order doesn't say that he has to surrender. Probably you have surrendered.
My lord,
And then on-
41A has two clauses, my lord. As
Ah.
per the judgment which they are referring, my lord.
Ah.
If arrest is required, can arrest.
Can
If
arrest.
is not required, 41A.
Hmm.
There's no necessary that
No,
41
Because probably
A has to be mandatory.
Ah.
That's why
Hmm.
I'm coming to a point, my lord, that otherwise, my lord, this is the case, my lord. This excavator is still at the station. The record says that this has been shown in the CGM. During investigation of the explorer government, the CGM UPI by so and so, hydraulic was shown seized. It is on the record with the CGM, the theory. Now the question is that only the section is that 30506, man. Criminal breach.
now probably after investigation, probably some other section may also be inserted due to the conduct of the case.
My lord.
That we do not.
My lord,
because
this is a
it still
case,
under investigation.
this is a case fit for this quashing.
You-
This is otherwise a
yes,
case
five-
fit
five-
for,
five-
I will be filing
Yes,
quashing
yes,
petition.
yes.
This is a case for fit for quashing.
Yes,
Now what I'm
only
saying,
one can file.
what I'm saying is that,
Hmm.
that whenever the offense is below 7 years,
Hmm.
court is recent judgment 220.
Yes, but here in this case, already arrested. He has been already arrested.
No, that's why already arrested. That's why now the question is whether absolute bail is to be regularized or not. Now the question is that when the investigation is saying that we don't need the person. That this is a case, my lord will see. Matter of is of.
Now, what is your prayer?
Bail
When-
may
when
be,
I'm
bail
granting-
may be
when-
made
when-
absolute. Bail may be made.
When I am making, when we are making absolute, then what is your prayer?
Well, bail may be made absolute, my lord.
Yes, yes.
I conclude my argument.
Okay,
Lordship,
yes.
please
What-
allow me a few minutes. I will bring some very interesting facts which the learned counsel has
We are
tried.
not on merit.
Yes, I am on merit.
No,
The-
we are not on merit.
I am not into merit, sir. I am within the four corners of this petition.
Hmm.
The petition AB 59/24, Tagung Neri, is not maintainable, sir. Now the question comes why? The agreement that the learned counsel has relied upon is a fake fraudulent document in my first signature. Now he will say I am lying.
You file a fact.
No, sir. That has already been done. The same agreement was attached by him in anticipatory bail petition 2355/19 filed by the petitioner in Guwahati High Court with relation to Dibrugarh FIR.
Then ultimately.
And he has been charge sheeted for
ultimately
forgery.
incorporate all those documents, and then during investigation, everything will come out, and then the charge sheet will be filed. against
Lordship,
him. Don't worry.
Lordship, just give me a minute. I am from Calcutta. I have traveled so long just to put my humble submission to
Yes.
you. Now, when I place before your Lordship that this petition contains a fraudulent document, can this petition be considered?
Have you submitted objection petition?
I have made this matter aware to the registrar.
No.
I was informed
No.
by registrar judicial
Have you
that
filed
it is on
objection?
judicial side.
Have you filed objection?
Yes, we have filed an objection to this. I have filed an affidavit, sir.
Affidavit.
This petition is not maintainable, sir. And I also draw the attention of this court that the learned counsel representing the petitioner is aware of the forgery, aware of the charge sheet, aware of the cognizance taken. Summons issued. How can he suppress the fact? We have brought this to the notice of the Bar Council even.
Take your seat.
And they have said
Take
section
a seat.
35 is required. Advocate said.
Probably he must have given his statement also, the informant.
Yes.
And then basing on the statement only after recording all those, only this IO has given it.
Given that observation.
Hmm.
My lord law says, where is the, my lord, he can control the investigation. We cannot. Investigation
Yes,
is an
yes,
independent
yes.
body. Now he wants that
Beyond-
today itself,
Hmm.
my lord, to decide which document is forgery, or he wants that his entire story has to be well accepted by us, as if he is only the honest person in the world.
No, you are the
All
last
person
person
are-
honest on this, sir.
And
But you have been
so
charge
far,
sheeted.
your charge sheet has been stayed by the Honorable
Not at
High
all
Court.
charge sheeted. Do you have the order?
Please,
Yes.
sit down, sit down.
Show the order.
It's okay. We are not on that point.
You are on that point. Show the order.
No, no, no. No,
If
Mr.
it has been
Please sit down.
Now he will decide how the
You are
investigation
making
is.
a very misleading statement, Mr. Thomas. You should know. If you have a stay order, show it. If you don't have a stay order, don't show it. Don't speak out of it.
Please don't shout.
Sorry, sir. I'm sorry.
Ignorance is bliss. I cannot shout. He can shout. Ignorance is bliss. Here, Your my lord.
Please take seat.
Ignorance is bliss.
And then,
Sometimes knowing the law is difficult. Not knowing the law is bliss.
when this CD was called for, Mr. Secretary.
25-6.
Okay.
Initially, on the last occasion also, the CD was sought for, and the Honorable Court has perused the case diary as well.
No, my lord, against him also investigation has been reopened, my lord. My lord wants the, see, I will just submit one order also. For his misdeed, learned CGM has passed one order, my lord, against him. That this investigation, Duimik police case should be initiated further because it was not done in a proper manner. So I am submitting the order. He is also accused. He is also accused now, my lord. Recently, learned CGM has passed the order, my lord. Earlier, this FIR that was closed by filing final report, my lord. I protested. Now investigation has been initiated against him. Now he is also one of the accused person for forgery, for cheating, for all those things. Now we don't know what will be the outcome of the investigation. He is under the scanner also.
What is this?
Against him, my lord, further investigation for all those fraud things, my lord.
This order was passed with 7-6.
Last
in connection with this case?
In connection with my FIR, my lord. I lodged one FIR against him, my lord.
Your FIR is not connected with this case.
This case connected. Because only, my lord, because of my FIR, police acted. That's why he lost this case. Why acted pursuant to my FIR? This is the offshoot of my FIR, this case, my lord.
Because of this FIR, section 182 has been imposed in the crime branch.
Section 182 cannot be done in this way. Cognizance cannot be taken under one section 82. 82 is a bailable offense. My learned friend has to understand the law. Now he wants that my AB anticipatory objecting on the basis of 182, which is a bailable offense.
Charge sheet, cognizance taken, someone issued, no state.
So where they have stated that the accused, is there any document when showing that the accused has already surrendered? If I there. And, okay, Mr. Connor, Learned Counsel for the petitioner. I have also heard Mr. Shiri, Learned Public Prosecutor, Mr. J. Shiri, Learned Public Prosecutor, Arunachal Pradesh staff. is an application for granting pre-arrest, application filed by the petitioner seeking pre-arrest bail, apprehending his arrest in connection with CBPS case number 02 so 2021 and 2023 under section 120B 403 406 182 IPC Indian Penal Code arising out of the FIR dated 22/04/2023. Now this is CBPS case.
Yes, Madam's PS case.
The CD is of the crime branch.
Yes, ma'am. SIT. CBPS case number 2 of 2023.
By an order dated 13/3/2024. The 24. Because the accused applicant has been granted interim anticipatory bail directing that in the event of his arrest in connection with the above CBPSS number 02/2023. He shall be released on executing a bail bond of rupees 20,000 with one surety of like amount. To the satisfaction of the arresting authority. Stop. Para. When they surrender, stop. Para. Person to, okay, thereafter, the accused applicant appeared before the IO of the case on either it will be in the last or in the first in the report, status report.
Yes, sir.
In the status,
good.
can see in the status report.
Status,
must
they have not
reflect-
mentioned it.
reflected.
On the last occasion when the CD was sought for, they have specifically mentioned in the status report as well. But since it's a new one, so they have,
In the status report, the IO must have mentioned that they appeared on so and so on its bail, they were shown arrested, released on bail.
should have been. Yes, my lord.
When?
No, mention the date, my lord.
Did not mention.
My lord. Last two paragraphs. You have not mentioned the date. In case it is, my lord, not able to find out the date, I can contact the IO and I can bring it on record.
Yes, because that is necessary. When they appeared and then released on, is there any, because to the satisfaction of the arresting authority, and what was his satisfaction, whether he asked for the appearance, etc. That is necessary.
I'll bring that on record by tomorrow. If
Okay,
matter is taken up tomorrow.
we'll pass order tomorrow then. As prayed for by, tomorrow already listed, day after tomorrow, as prayed for by the Land Council for the parties. List this matter again on day after tomorrow. When
Not,
day after tomorrow is
it's only for order, my lord, right?
order.
only-
Because the, yes, EP will,
Date of the surrender.
so find out and then, if he has the, because their
Bail
execution,
execution.
that also will be there. So WhatsApp also you obtain that order copy. So if he has already been released, no point keeping it hand. Okay. This, day after tomorrow, not this court, huh? Day after tomorrow. only. Huh? Today is 25, 27, reach it on 27, huh? 7 and 8. Okay. So, there's one would be required.
Yes, ma'am.
And then whether your complaint that you have just earlier submitted, whether you informed, sorry, the FIR also registered against them,
Yes, sir.
subsequent FIR also, that is fine, they will investigate and you pursue that. It is not connected here, because that is, that arise out of the case and another case against them. So let them say.
But the
investigate.
document is the very same there and here. the same
Maybe,
thread.
maybe, but then you see, in the same case, so many cases may arise. In the same case, because if he produced false document and then he failed lie, violate, etc., so many things will arise. Don't worry.
Lordship, I have just a simple phrase.
Yes.
That it may be recorded that the informant has brought to the notice of the court that the
No,
agreement
that
relied
is not-
upon is the forwarded one. That much will do. We are not into anything that we are out of that. Please record that and that will do.
Obliged.
Much over.
Okay. So, I think, huh? So the rest of the case will be item? 9 also will take up, 9. This is fresh or?
No, Lordship.
No, Your Lordship,
Interim is there.
interim was granted, and his statement was recorded, but as per the IO, after recording of the statements, he was called twice, but he didn't cooperate with the investigation. So, Your Lordship,
So the AB goes.
no, Your Lordship, no, I'm not objecting, objecting, Your Lordship. I'm simply saying,
What
make a
is-
submission that Your
what is the
Lordship,
status report?
investigation is going on, it's pending. Your Lordship, let them direct to appear before the IO and call for the fixing a date and call for the updated case diary so that whether he has cooperated with the investigation, Your Lordship.
Okay,
Even day before yesterday, I have been to
okay.
police station to meet the IO.
Land Council for the petitioner, Mr. Arigo. I've also heard Mr. Edmund T. April, Land Additional Public Prosecutor for the state of AP staff, huh? The Land Additional PP submits that after obtaining interim anticipatory bail, the accused is not appearing.
No, Your Lordship, after obtaining the anticipatory bail, he appeared on 10/6/24. Initial statement was 161 statement was recorded. For further investigation, he was called for, but he didn't appear. That is the only.
Obtaining interim anticipatory bail, after appearing once, the accused is not appearing before the eye of the case for further investigation?
Lordship, I have appeared 3 times before
Often.
IO.
3 times.
Yes, Lordship.
Your Lordship, it's not, as per the,
First, I appeared on
After
7th.
appearing in the initial stage, before the accused is not appearing, not cooperating the eye of the case, eye of the case for further investigation of the case. However, the learned ADPP prays for production of updated CD. Prays for allowing prays for some time to obtain further instruction and to produce updated CD.
Yes,
The
sir.
prayer is allowed. Please this matter when
Your Lordship, in the meantime, the accused may be directed to appear, Your Lordship. Since
this matter
after break, Your Lordship,
after vacation, immediate after vacation. In the
on
meantime-
16th, Your Lordship,
Huh?
on 16th.
On 16, stop. In the meantime, the accused. Oh, the accused. In the meantime, the learning counsel for the petitioner submits that undertakes that the accused will cooperate and appear before the eye of the case. Okay. List is matter on 16.
Lordship, till 16, I may be interim may be continued.
In the till then, the interim or the past earlier shall continue. Okay.
Deeply obliged, Your Lordship.
Okay. None appears, case stand adjourned. List, okay. 14. Okay, no one appears on behalf of the petitioner. However, Mr. And the learned additional PP is present. In absence of the petitioner, the case is stand adjourned. List this matter after 3 weeks.
Yes, sir. Deeply obliged, Your Lordship.
And what else? 17. No one, Okay, no one appears on behalf of the parties. List this matter after 3 weeks. Okay. What more? 17 matter. You are in item? 17 matter. 17.
This can be
Okay.
listed after vacation, madam.
After vacation. You are for the petitioner here?
Yes, madam.
Okay, Mr. L. Parme, learned counsel for the petitioner is present. Is prayed for by the learned counsel for the petitioner. List this matter after vacation.
Oh, highlight.
17 and 19, no?
Your Lordship,
May I please, Lord?
let the matter be adjourned today, kindly.
After?
Anything said.
My Lord, this is a make appeal, my Lord. MSCD
Make
appeal.
appeal.
Yes, my Lord. Can
You
it
are
be
for-
taken up on Friday, my Lord?
Huh?
Can it be taken up on Friday, my Lord?
Friday, it will be difficult. Friday will, the next case will be listed because I'm leaving out.
That will be on
So-
15 then, my Lord. 15th of July.
15 or 16, yeah?
15th of July.
Okay. Is prayed for by learned counsel for the appellant. List this matter. You
I
are for the
respondent. Yes.
You are for the appellant.
Yes, Your Honor.
Is prayed for by the learned counsel for the parties. List this matter on 16th July. Okay,
Obliged.
Obliged.
16.
yes. Anything else? Finish. Okay.